Irwin, as one of Canada's, and I'm not saying this to flatter you, one of the greatest ministers of justice, renowned all over the world from some of the work you've done, what do you see in your role as a former Minister of Justice are the two most fundamental principles that the Minister of Justice and the Attorney General of Canada, who has the role at the same time, has to do to promote the rule of law in Canada?
Well, I recall when I was sworn in as Minister of Justice and then subjected to the proverbial media scrum, which was basically the beginnings of a gotcha journalism for ministers. Before they could begin with their approach, I said that I wanted to just set forth my own set of principles. And I began by saying that I will be governed by one overarching principle. I said, and that would be the pursuit of justice. And within that, the promotion and protection of the Charter of Rights and Freedoms as a centerpiece for the building of a just society, and the promotion and protection of equality for the building of a society that was not only just, but one that was compassionate and humane. I must say, and I think we all bring our own identity to whatever we do, that I was, at that point, hearing my own parents speaking to me, my father, who had told me that the pursuit of justice was equal to all the other commandments combined. And then my mother saying to me, when she heard my father saying this, that if you want to pursue justice, you have to understand, you have to feel the injustice about you. You have to go in and about your community and beyond and feel the injustice and combat the injustice. Otherwise, the pursuit of justice remains a theoretical construct. And was not unlike, and I think I was fortunate that I was 30 years as a constitutional law professor and had the benefit of Frank Scott, one of Canada's great constitutional lawyers, who taught me, who said that constitutional law was a law for making laws. He called it the ultimate rule of law. So two basic principles that came out of that from my parents and from Frank Scott and teaching were the following. The first was what I called, and this is I saw as a governing principle, the notion of constitutionalism, human rights, and the rule of law. That we had, by reason of the advent of the Canadian Charter of Rights and Freedoms, which I said would be an organizing principle for me, we had in effect undergone in Canada, Rob referred to 1982, had undergone a legal revolution, which the late Chief Justice Antonio Lemaire said was a revolution not unlike the developments by Pasteur in science. Now, you might think that that was an over-enthusiastic statement, but Claire Ledoux-Dubé said around the same time that as a result of the Charter, we had stretched the cords of liberty in Canada more in 5 years than the U.S. Supreme Court had in 200. Okay. Allowing for that, as I say, an enthusiastic approach to the Charter, and I do share a lot of the approach of the Charter as a Grundnorm principle, I think we had to appreciate, as a result of the Charter of Rights and Freedoms, that we had moved from being a parliamentary democracy to being a constitutional democracy. We had moved from the sovereignty of Parliament to the sovereignty of the Constitution. We had moved from the courts being arbiters of legal federalism, which they still remain, to being guarantors of human rights. And I walked in on this about the activism, not because the courts sought to usurp that power, but because we, Parliament, entrusted them with that power in the adoption of the Constitutional Act and the and its centerpiece, the Charter of Rights and Freedoms. And individuals and groups now had a panoply of rights and remedies that they did not have before, and an expansion of the justiciability issues that did not exist before. You could not, in pre-charter law, have standing to go before the court and seek to give equal access to gays and lesbians to civil marriage. Simply was not a justiciable issue. There was no standing in that regard. And so, as a Minister of Justice and Attorney General in that regard, I'll close on this point, I felt that I had a responsibility to ensure that all laws that would be introduced would in fact comport with the Canadian Charter of Rights and Freedoms. In fact, it was an obligation under Section 4 of the Department of Justice Act. And I sought to mainstream this within Cabinet, within justice officials, etc., to create this as a kind of organizing norm, a culture of governance. You were speaking about good governance, as a kind of culture of governance of which Nathalie spoke of. Regrettably, I have found since, and I don't like to be partisan, but I'm not saying anything here that I've not otherwise said before. I felt that the Conservative government has introduced a series of legislation which is constitutionally suspect. One of the most important of them is in the field of criminal justice, not unsurprising because a law and order agenda was germane to the Conservative government. But Bill C-10, and this brings us into the whole question, both of good governance on parliamentary process and constitutionalism and the rule of law. Because in the Bill C-10, first of all, you had 9 pieces of legislation, each of which deserved its own differentiated and distinguishable oversight, if you will, by Parliament. So I'm not speaking here about, government opposition. All parliamentarians, obligation to give legislation the proper consideration. But not only did you have 9 bills wrapped in one, but then time allocation, which is a new term for closure to make it more sanitized. Time allocation was introduced not only in the House, but introduced in committee. And so when this omnibus bill came to committee, we had a kind of fascinating situation. I had proposed about 45 amendments to the Bill C-10. All of them were summarily defeated. But one of the bills, interestingly enough, one of the bills had been a private member's bill that I had proposed earlier. That was to give civil remedies to victims of terror. The government had included that because of civil society representation as part of their omnibus bill. So I proposed the 6 amendments, and the government summarily rejected the 6 amendments. I said, I'm only trying to improve your legislation, and the legislation that, in fact, if you will, civil society has asked that you include, summarily rejected. The same civil society groups then went back to the government and say, hey, if you want that legislation, you need those 6 amendments. So they then brought back the 6 amendments and brought it back at report stage. And this is where procedure comes in. The Speaker then correctly said, you can't bring back at report stage, which you rejected, I don't want to get technical, rejected at committee stage. So as a result of it had to go back to the Senate, come back, etc. And at the end of the day, the 6 amendments that they introduced for this bill to give civil remedies to victims of terror were the exact 6 amendments that I had proposed without a change of comma that they had summarily rejected earlier. So that's what I'm saying, the whole things can converge, and it's regrettable when those things happen, because with this I close, when you introduce constitutionally suspect legislation, the result of it is you invite constitutional challenges, and Bill C-10 is replete now with constitutional challenges, whether it be with regard to mandatory minimums, whether it be regard to prison overcrowding, whether it be regarded to pretrial, a whole series, because it's an omnibus bill, so there's a lot of constitutionally suspect provisions. So it invites constitutional challenges. It, in fact, abuses resources, both of government and the courts. It strains the legal process, and it breaches, in my view, the government's initial responsibility to comport with the Charter of Rights and Freedom. So that's my whole approach on that. Just a parenthetical aside, but not so much on equality. Since I missed the first round, I'm just stealing a minute or two. On the issue of equality, because that was such a foundational issue, as Minister of Justice in 2005, I proclaimed 2005 as the year of equality. I have to say that, again, the government, and I remember we used to have conferences celebrating the Charter, and it's very annually. Conservative government sort of almost ignores the Charter as if it's not there, and has even instructed its officials not to appear at conferences that annually, at the annual commemoration of the Charter. But on the equality issue, that was fundamental with regard to bringing about the Civil Marriage Act. Without that, we could not have had a civil marriage. There are other things in which equality is fundamental, but I'll stop here. For me, the 2 Grundnorm principles, therefore, were number 1, promotion and protection of the Canadian Charter of Rights and Freedoms, number 2, the promotion and protection of equality, and where the Minister of Justice and Attorney General of Canada has a distinguishable responsibility with respect to both, and it starts right at the beginning in cabinet, whereas the Attorney General, and you made this point, as an Attorney General, you have to give independent legal advice to the Crown, and that has to comport with the Charter, etc.
Thank you, Owen. Owen, I'm not going to ask you to think about something, because I know you probably have 7 points. You always have 7 perfect points on any issue, so I'm not going to ask you any questions.
I'm just gonna, you know what my son says, Dad, it's a new generation. After 2 points, we're gone. We're not there anymore.
And Owen, one of the things connected to everything we've heard so far is, especially given what happened in October, if we are, if you like, I hate the word war, the war on terror, but if we are in a permanent law enforcement regime on the so-called terrorist threat, what is the role of government? What's the role of the Department of Justice in terms of making sure all the issues that David has talked about, that Nathalie's talked about in terms of proportionality, in terms of not overacting, not overreaching, at the same time as the Minister of Security is now using a new term, not underacting either. So I know you're coming to national security as being one of the principles on the rule of law, so maybe you can address it now.
Yeah, on the issue of national security, I never felt that there was a necessary contradiction between the protection of national security and the protection of human rights. They intersect, they're complementary, and I used the term, it wasn't mine, it was even first initiated by Lloyd Axworthy. It was the notion of human security as a kind of generic principle. By that I mean, on the matter of security and rights, that there are 2 foundational principles, and this goes right into, let's say, the situation of a terrorist threat and the like. The first is that terrorism constitutes a threat to the security of democracy, like Canada, and the rights of its individuals to life, liberty, and security of the person. Therefore, in that context, anti-terrorism law and policy can be seen as being the obligation of government to protect the security of a democracy and protect the life, liberty, and security of the person of its inhabitants. As former Supreme Court Justices Frank Iacobucci and Louise Arbour said, the Constitution is not a suicide pact. There is an obligation, to protect the security. At the same time, and this is the second and related principle, at the same time, the anti-terrorism law and policy must always comport with the rule of law, must always adhere to the Charter of Rights and Freedoms. Torture everywhere and always must be prohibited. Individuals and groups must never be singled out for differential and discriminatory treatment. And so a government has a responsibility with regard to the protection of democracy and the protection of its citizens from terrorist threats, but in doing so, it must always comport, as I say, with the rule of law and the Constitution. That's why, interestingly enough, one of my first acts as Minister of Justice was to recommend the establishment of the Commission of Inquiry to Maher Arar at the time. This also became an interesting situation for me personally. The Commission of Inquiry was established. I had acted, and Rob, maybe I should have consulted you on this at that point. I had acted as counsel to Maher Arar when he was in prison in Syria after the illegal rendition from the U.S. to Jordan, Syria, etc., and took up his case, and we organized a hearing on Parliament to look in the whole situation. But then, having established the Commission of Inquiry, I was told I had to recuse myself because of my prior involvement with the Maher Arar case, the result of which I was not subsequently involved. And then I realized if I was going to recuse myself on all issues that I had been involved in as a human rights lawyer prior to becoming Minister of Justice, I wouldn't be able to discharge any responsibilities at all, because whether it be on the issues of bringing war criminals to justice, whatever you wanted, I had some sort of track record over the years, having come late to being the minister in my, being in my 60s. So I figured, well, if I'm going to have to remove myself from everything that I'd been involved, so I then after that happened, after I recused myself in Meher, I said, okay, I'm now making it clear, I will not recuse myself anymore as Minister of Justice. Either you trust me or don't on the issues that come before me, that I will discharge my responsibilities appropriately in accordance with the rule of law, etc., but I will not any longer recuse myself. So that was on the relationship with security and rights and the kind of personal aside. But some of the things we recommended at the time have still not happened, which was, to use one example, establishing an all-party parliamentary committee, a kind of security and intelligence committee that would operate for purposes of oversight. We don't have that. And now we have a situation where the government is seeking more powers when I think we need more oversight. And this is something that we're going to have to work out in the weeks ahead in this regard.
Thank you, Irwin.